in the global economy that we all live in, the competition for consumers and consumer attention is key for many manufacturers of goods. And one way to do it, obviously, is to use interesting shapes for the products that are being offered. And today we'll talk about how to protect such shapes, what to do to differentiate the shape from the shape of a competitor, and how to protect it against competitors. We'll start with designs, because that, I believe, is the natural way to protect the shape of a product. Then we will discuss trademarks and some recent cases from the Court of Justice of the European Union. We will then move on to competition, unfair competition, or passing off, which could be an additional instrument of protection. And we will end with copyright protection, which could be the very last resort. I would like to start by just discussing some of the cases that concern bottles. And starting from the one to your right, the first case concerns an attempt to register a bottle as depicted as a trademark. This attempt was made by Voss of Norway, and in the initial phase of the proceedings, the registration was denied. The case, as you can see, reached the Court of Justice of the European Union, and the court discussed at length the reasons and the grounds and assumption that should be taken into account when deciding on registrability of a 3D shape of a bottle. Now, I would like to very briefly discuss patent protection for shapes. I will not go into details of patent registrability, of conditions for registrability of patents, mainly because patents remain territorial and national, in a sense that there is no EU patent, and therefore to obtain registration for a shape of a product, an entity, an applicant has to follow a national procedure.